to this year's Constitution Day James Otis Lecture Series. My name is Robbie Foster, and I'm serving as the president this year for the South Carolina chapter of the American Board of Trial Advocates, which I'll explain a little bit more in a minute. I'm a lawyer here in Columbia, South Carolina. First and foremost, the ABOTA Executive Committee and presenters would like to congratulate you students for being selected by your respective high schools as James Otis Scholars. That is quite a credit to you, your reputation within the law school, and we appreciate you taking time out of your school schedule to participate in this very important Constitution Day lecture. It is our honor to present this Constitution Day program to such an esteemed group of students who will shape the state and the country in the future. Each of you are the future of this state and this country. I recall when I was a high school senior and I heard that, it didn't really make a lot of sense to me because I'm thinking, how can I as a high school senior be the future of this country? I have learned in the last 40 years that I can have a big impact on both this state and this country when I was seated in the chairs each of you are seated in today. So a few words about the program itself. We are hopeful that you will find this both educational and entertaining. And we are dealing with some cutting-edge issues in society today. Our purpose this morning is to provide you with some interesting historical information about our U.S. Constitution, and this year we picked the Second Amendment. Each year we pick a topic within the U.S. Constitution, and this year it was hard for us to avoid the issue that we all read about every other week or so, the Second Amendment, and the right to keep and bear arms. Now, each of you has a pocket Constitution in your packet. Feel free to pull it out. You might want to refer to it during the discussion. You may just want to look at the Second Amendment that's in there. So you have the full Constitution in your material. So feel free to pull it out and determine, okay, where is the Second Amendment within this constitutional document? At the end of the program, we're going to do something we've never done before. We're going to ask you all to vote, and you have a ballot in your packet. And we have 2 gun control proposals. And you have a small ballot that looks like this. We want you to pay attention to the presentation, and our gun control advocate, Zach Horan, who is a third-year law student, has proposed 2 gun control measures that you will vote yes or no. The first one, universal background checks required to all transactions involving the transfer of firearms. You will vote yes or no. We will tally these votes. We will let you know the outcome before you leave today. Number 2, eliminate the sale of high-capacity magazine firearms by limiting the magazine to 10 rounds. Yes or no? Now, a little bit about the American Board of Trial Advocates. That's who we lawyers are members of. It's also referred to as ABOTA. The American Board of Trial Advocates, we are the South Carolina chapter, and there's a national organization of ABOTA as well. This organization is dedicated to preserving the 7th Amendment, the right for civil jury trials. And we believe this is a fundamental right in the Constitution, and just as with almost any right within the Constitution, people are trying to erode that right. We believe that the jury system, cases being decided by your peers, is the best way to resolve disputes in civilized society, and so we constantly are on the lookout to make sure no one threatens that right in any way. The second mission for ABOTA is to dedicate ourselves to professionalism and civility. Nowadays, professionalism and civility among lawyers is on a decrease, and ABOTA is engaged in numerous national efforts to promote the value and the importance of civil debate and professionalism. We believe very strongly that every lawyer should show the utmost respect for opposing counsel, the court, the litigants, and the entire litigation process. Many of you see on TV all this crazy lawyer fighting. We're opposed to that. We do our best to model the way you can have a civilized dispute and present your case professionally and let a jury and a judge decide that. Basically, ABOTA promotes the golden rule: do unto others as you would have them do unto you. Now let me just briefly at this point introduce to you who are seated up here. To my far right is Sam Alton. He is the immediate past president of this chapter. He is a partner in the Greenville firm of Womble Carlisle. Reese Williams is a partner in Columbia Law Firm, and he is both a past president of this chapter and the national ABOTA organization itself. He is the one and only South Carolinian who's risen to the top of the national ranks. Next to him, Joshua Gallivant. Joshua is going to present to you a high school student's version and understanding of the U.S. Constitution. Senior at Dutch Fork High School, mock trial debate team, ambitions, I believe, to go to law school one day. So he'll be presenting your viewpoints on what does the Constitution mean to high school students. Next to me, Zachary Horan. Zach is a third-year law student at USC, West Point grad, served in the military. He will be presenting his proposal for levels of gun control. Next to me on the left, David Keene. David is the immediate past president of the NRA, the National Rifle Association. He came down here from Washington yesterday afternoon, and he will be, he is currently on the executive committee and the board of directors of the NRA, and he will be presenting the Second Amendment right to keep and bear arms. Next to him is Dean Robert Wilcox. He's the dean of the law school. He comes to this program every year. A lot of students seem to be interested in law school, and at the question and answer session, if any of you have any questions about law school, the pros and the cons, and what's going on with the USC Law School, Dean Wilcox will be here to answer those questions. Next to him is Sandy Stern, partner in the Greenville firm Covington, Patrick, and Stern. He is the president-elect of the South Carolina chapter. And then next to him is John T. Lay, partner in the Columbia firm Gallivan, White, and Boyd, and he is the treasurer of this organization. So we hope that you all will get engaged with the discussion. You will have questions and answers at the end. You will be asked to vote. We want to see what this group of people at your level think about gun control and gun rights. So, without further ado, we will now have the presentation of colors by the Dutch Fork High School Air Force ROTC Color Guard. And immediately after that, Reese Williams, our former president, will lead us in the Pledge of Allegiance.
Please join me in reciting the Pledge of Allegiance. I pledge allegiance to the flag of the United States of America and to the republic for which it stands, one nation, under God, indivisible, with liberty and justice for all.
Order! Colors! Out! March!
Okay, you may be seated. Thank you, Reese. Thank you, Dutch Fork High School Color Guard. Next, I would like to introduce our treasurer, John Lay. He's going to describe the two South Carolina scholarships that we'll be offering to two lucky recipients.
The University of South Carolina will be awarding two scholarships in recognition of the outstanding students who have been selected from high schools throughout South Carolina to attend today's James Otis Lecture. The University of South Carolina will offer two $6,000 scholarships to attend the University of South Carolina. Each scholarship pays $1,500 per year for 4 years at Carolina. I want to give special thanks, and on behalf of ABOTA, the South Carolina ABOTA chapter, to Mark Bike, who is a board trustee with the University of South Carolina and who is also a dedicated member of our chapter, for procuring these two scholarships. The winning students' names will be submitted to the University of South Carolina, and you will be contacted with scholarship data for the incoming freshman year of August of 2014. You must qualify academically to attend Carolina to be eligible for the scholarship. Should you decide not to attend the university, please advise your school's guidance counselor as early as possible to contact the ABOTA Executive Director, Patty Kavanaugh, at the address that is in your materials, because we're going to have alternates. So if you decide not to use it, please let us know, and alternate recipients will be notified. Congratulations to the two scholarship recipients. We'll be announcing those soon. Thank you.
Thank you, John. And the way we're going to do the scholarship is Sam Mountain and I will pull the names out of the hat while we're tabulating the vote, and the first two winners have the first right, but we will then draw two alternates. So we'll be drawing 4 names, and if the one or two of the original winners do not attend the University of South Carolina, or they just don't want the money, then the alternates, their name will be put in there. So who was James Otis? And frankly, the first time we did this program, I had to ask myself that and had to look it up in a book to see who James Otis was. So we thought this is the name of the lecture series that National ABOTA has actually put on this. And as it turns out, James Otis was one of the most influential lawyers in early American history before the U.S. Constitution signing. And so what I'd like to do is ask our President-elect, Sandy Stern, a lawyer with the Greenville firm, Covington, Patrick & Stern, to come up and give us a little history lesson about who this famous James Otis really was.
Good morning. Before you were selected as James Otis Scholars, how many of you had heard of James Otis? Don't be alarmed. I feel like I'm in good company. Well, first and foremost, James Otis was a lawyer, educated at Harvard, and admitted to the practice of law in Massachusetts in 1748. In the period before our revolution, he was considered to be the country's leading lawyer. So why do we celebrate him with a lecture series on the Constitution? Our Constitution did not appear out of thin air. All of you know that the idea of revolution began long before shots were fired at Lexington and Concord in April 1775. What John Adams described as the revolution in the hearts and minds of the people began with the reactions and resistance to oppressive taxation measures by the Crown. In 1760, the Court of the Exchequer in England, at the direction of Prime Minister William Pitt, issued writs of assistance to customs officers, which allowed these officers and their underlings to examine any place where contraband was expected to be, contraband being untaxed goods where no customs duty had been paid. You all know how these were received in the colonies, particularly in Boston. As one author described the writs of assistance, any public house, public or private, might be entered at any time. Any closet or any cellar might be opened. Neither the bridal chamber nor the room of the dead was sacred on the approach of any petty customs constable or deputy in whose hands a writ of assistance had been placed. The antecedent proceedings required no affidavit or any other legal formality. The object was to lay bare the whole privacy of a people on sheer suspicion of smuggling. In February 1761, the issue of the legality of the writs was brought to court. At this time, James Otis had taken the lucrative position as Advocate General of the Admiralty Court, making it his duty to advocate the king's position on the side of the Customs House officials to whom the writs were issued. When those revenue officers came to him with their case, Otis resigned his position immediately and took up the cause of the merchants opposed to the writs, one of whom was John Hancock. What's more, he took this up for no fee, pro bono. It was this trial which John Adams believed began the revolution in the hearts and minds of the people. John Adams attended that trial and made copious notes of Otis's arguments. He began his 4-hour oration against the writs with these words: "May it please your honors, I will to my dying day oppose with all the power and faculty God has given me all such instruments of slavery on the one hand and villainy on the other, as this writ of assistance is. It appears to me the worst instrument of arbitrary power, the most destructive of English liberty, and the fundamental principles of the Constitution that was ever found in an English law book." Otis went on to argue the sanctity of home and property with the phrase that you've all heard before. A man's house is his castle, and whilst he is quiet, he is as well guarded as a prince in his castle. Otis is a man to be admired for his zealous advocacy against tyranny and for his strength of character. Otis' example should be a reminder that what was secured by our Constitution came at great expense. James Otis lost his case on the writs of assistance, but in defeat he became a hero to many, especially John Adams. The principle he sought to vindicate, unlawful searches and seizures, was later enshrined in our Fourth Amendment. Otis has been described as the forgotten patriot. ABOTA, our national organization, created the James Otis Lecture Series not only to make us remember James Otis's contributions, but to educate and to inspire students across the country about our Constitution. This week, on Constitution Day, which was the 17th, and through today, there will be 10 similar lecture series to this all around the country. We commend you for your achievement in being selected as James Otis Scholars. Thank you.
Thank you very much, Sandy, for that history lesson. So when you all go home tonight, ask your older brothers or sisters or parents, do you know who James Otis is? And if they don't, then tell them you learned all about James Otis at the lecture series today. The reason we're doing this Constitution Day, if you all don't know, Tuesday, September 17th, was Constitution Day in this country. And so we're trying to put on a program in honor of Constitution Day. We normally do it on a Friday just because it's easier for the students. And each year we invite a high school student to present a presentation on what the U.S. Constitution means to him or her. And this year, Joshua Gallivant from Dutch Fork High School was selected to speak on what the U.S. Constitution means to him. Josh participated in the Dutch Fork mock trial debate team. And Josh, thank you for coming, and congratulations on being selected to speak about what the U.S. Constitution means to you.
Good morning. First and foremost, I must thank Ms. Kelly Payne, Ms. Koch, and as well as Ms. Patty Cavanaugh for granting me with this grand opportunity. I truly could not have done this without their help. I once heard a man say that law is order. Though this makes sense existentially, I thoroughly disagree. Law is and has always been chaos pursuing chaos. What I mean by this is that law is by no means perfect nor pristine. The law can be vicious, unkind, vitriolic, and vague. Yet through all of its blisters and blotches, it remains beautiful. Beautiful in the sense that it protects the callow and brandishes the brave. Beautiful in the sense that it quarantines the unjust and shuns the inhumane. Beautiful in the sense that within the Constitution's vast walls, there is power to right wrongs and enact change. But most beautiful of all are those words that grant each and every American virtuous, unalienable rights that can never be taken away. My first experience with the Constitution came in the 3rd grade. After an eventful recess, our teacher settled us down and explained that each and every one of us would be memorizing and reciting the preamble. As the chorus of groans and growls began to grow, I sat silently, wondering, what exactly would this mysterious assignment entail? What was the preamble? Why did it matter? And most of all, how could I get out of it? Our teacher began to go over the doctrine, word by word by word, until eventually someone mustered the courage to ask the looming question. What was the preamble? She paused, caught off guard by the clarity of the question. Finally, after traveling through every safe answer imaginable, she gave an accurate, straight-to-the-point answer. In her best teacher voice, she said, "The preamble is the prelude to the Constitution. It is the basis of our government." And with that, the burning curiosity of 20 third graders was vanquished. All except one. I yearned to learn more. An elementary understanding of how things worked was never enough for me. I asked question after question until eventually I was silenced for the betterment of the group. Still, I wondered, what was this thing, this ambiguous authority, this immobile mastermind that could craft the country so thoroughly? The fact that this seemingly invisible impetus known as the Constitution could hold so much power filled me with inspiration and awe, even at such a young age. And in a way, has crafted my conscience ever since. At the time, I did not know the Constitution had already impacted my life in such gargantuan ways. For example, it was the Constitution that ascended in the argument that abolished the chains of my ancestors. It was the Constitution that granted my grandfather the opportunity to become the first African-American deputy sheriff in a then segregated southern town. And it was the Constitution that aided my father, along with his 4 siblings, to rise from the restraints of poverty, gain a college education, and truly live the American dream. There are many technical elements one can pull from the Constitution, such as legislative procedure, presidential privileges, and even the salary of congressmen. You know, the boring stuff. But what I draw from the Constitution is something much deeper and more abstract. See, from a young age, I was hard to pin down. Yeah, I loved sports, candy, and video games, oh my, but what I loved most was the constant concentration of crime shows in circulation on my television. As cliche as it sounds, I was indeed a law and order junkie. Yet, more times than not, I would bypass the actual crime part of the show and focus solely on the court case, where in my eyes, the true magic happened. My love for the law quickly manifested, and by the age of 12, I gave up fictional court cases and began to obsess over real ones. I traded sports heroes such as Kobe Bryant and Randy Moss for true defenders of justice, such as Thurgood Marshall and Sadie Alexander. Clarence DeRoe, Sir Thomas More, John Adams, Gandhi, Abraham Lincoln, and of course James Otis all played a part in constructing my conscience and forming my undying love for the law and the Constitution. These men and women all interpreted the law through different lenses, and yet they managed to change the world. When it comes to something as monumental and boundless as the Constitution, interpretation becomes indispensable. I can only imagine the framers of our glorious document engulfed in insight, apprehension, aptitude, and wisdom as they crafted what would go on to become the greatest display of freedom in the natural world. Yet I wonder, did they know the various laws of the Constitution would cause such complications? Did they know that even the most minuscule of details described in the doctrine would evoke such pother and uproar? Did they have the slightest idea that key crucibles of the Constitution, such as the Bill of Rights, the Elastic Clause, and the First Amendment, will be the leading cause of some of the greatest debates in the history of the United States of America? Oddly enough, I believe they did. For I believe without controversy, contention, dispute, and debate, a document as beautiful and complex as the Constitution could not live. I believe the framers of our Constitution knew this all too well, so they constructed a country, a way of life, a Constitution worth fighting for. We, the American people, are blessed to have a document baptized in the waters of hardship, turmoil, and struggle. We are blessed to have a government that, while on the national level is designed to aid the well-being of its people, also recognizes that it's the aptitude of the states that truly understands what is best for its people. We are sanctified to have within our rigid walls of authority and rights the beating heart of the Constitution known as the Bill of Rights. The Bill of Rights graciously dictates religion, privacy, and most of all, freedom back to its people. Whether it be the First, Fifth, or Ninth Amendment, the various rights of the people are gorgeously woven into a system where the individual rights of one man or woman means everything. The Second Amendment is a great example of this principle. The constructors of our Constitution could not have foresaw the evolution of firearms. They could not predict that in the future, machine guns and other automatic weapons could turn an adolescent teenager or even a deranged adult into a one-man militia. Yet, they placed the right to bear arms in the Bill of Rights, knowing the importance and necessity of this right. Even though they could not see the reasons for discord, they knew all too well that the Second Amendment would be challenged and therefore made the right very clear and construct. Whether or not this tenacious right to protect oneself and bear arms comes with provision is the looming question. Either way, discussion and debate birth the opportunity for resolution and insight. And as long as the flames of democracy and debate continue to flourish, so does our freedom. Personally, I see the Constitution as a representation of human nature. Anything as monumental and adaptable as the Constitution truly shows the aptitude human beings have for intellect and progress. For my father once said, "Never let yourself be defined by one thing." And the Constitution truly is a medley of ideology, beliefs, and practices. One cannot constrict the Constitution to one definite clause or article, just as one cannot conform America to one people or belief. The complexity and intricacy of our Constitution mirrors how our country is more than just the story of an underdog. America is anomalous, fearless, exceptional, and unique, and this can be seen in our way of life as well as in our Constitution. Thank you, and God bless America.
Josh, thank you very much. You've done yourself and your high school proud. If you ever meet your dream of going to law school, which I have no doubt after hearing that you will, you've got 1, 2, 3, 4, you got about 5 law firms that'll be knocking at your door asking for, summer associate position. So make sure you get in touch with us when you get to that law school. Okay. And thank you for the segue to the Bill of Rights, which is our next presentation. The Bill of Rights, I'm going to ask Reese Williams, a partner at the Callison, Ty, and Robinson firm here in Columbia. As I mentioned earlier, Reese was not only the president of this chapter, he was the president of National Abota in the year 2000? Was it 2000?
I can't remember that.
Okay. So, he is gonna he's gonna give us a description of the Bill of Rights. Thank you, Reese.
Thank you, sir. A brief history of the Bill of Rights. Thomas Jefferson, December 20th, 1787. A Bill of Rights is what the people are entitled to against every government on earth, and what no just government should refuse. The little booklet that you have of the Constitution and Bill of Rights has on page 21 the beginning of the amendments to the Constitution, and the first 10, of course, are generally referred to as the Bill of Rights. In the summer of 1787, delegates from the 13 states convened in Philadelphia and drafted a remarkable blueprint for self-government, the Constitution of the United States. The first draft set up a system of checks and balances that included a strong executive branch, a representative legislature, and a federal judiciary. The Constitution was remarkable, but it was deeply flawed because, for one thing, it did not include a specific declaration or bill or list of individual rights. It specified what the government could do, but it did not say what it could not do. It did not apply to everyone. When it said the consent of the governed, it meant propertied white men only. So the absence of a Bill of Rights turned out to be an obstacle to the Constitution's ratification by the states. It would take 4 more years of intense debate before the new government's form could be resolved. The Federalists, an identified group or party at that time, opposed including a Bill of Rights on the ground that it was unnecessary. The Anti-Federalists, who were justly afraid of a strong centralized government, refuse to support the Constitution without having specific rights guaranteed and reserved to them. In the end, popular sentiment was decisive. Recently freed from the despotic English monarchy, the American people wanted strong guarantees that the new government would not trample upon their newly won freedoms, such as the freedom of speech, freedom of press, freedom of religion, nor upon their right to be free from warrantless searches and seizures. So the Constitution's framers heeded Thomas Jefferson, who said, "A Bill of Rights is what the people are entitled to against every government on earth, and what no just government should refuse." The American Bill of Rights, inspired by Thomas Jefferson, drafted by James Madison, was adopted, and in 1791, because of it, the Constitution's first 10 amendments became the law of the land.
Thank you very much, Reese. Reese has been instrumental in this South Carolina chapter. He makes sure, as other officers, keep everything in the middle of the road, and if any of us slack off, Reese lets us know about it. So thank you very much for helping us with this presentation this morning. So on to the specific Bill of Rights. That's the subject of this morning's program. The first 10 amendments are the Bill of Rights. We've done presentations on civil rights and freedom of speech, and today we're going to talk about the Second Amendment, the right to keep and bear arms. It's my pleasure to introduce to you Sam Alton, who was the president of this chapter just last year, partner in the Greenville office of Womble Carlisle. And so, Sam, I'm just going to turn it over to you to maybe explain to everyone what is the format of the discussion, and maybe explain a little bit about the ballot that they'll be dealing with at the end of the presentation and the end of the questions and answers.
Thank you, Robbie. Good morning. I must say I do hold the best position you can have, and that is immediate past president. You will learn that, trust me. The South Carolina chapter of ABOTA is pleased that all of you have chosen to attend this year's James Otis Lecture program, and also congratulations on being selected by your high school. We hope that today's program will increase your interest in our Constitution, and that you will decide to research and study this amazing document, which is the foundation of all of our laws in this country. My purpose is to explain briefly to you the issue which will be discussed today and introduce you to our speakers. As you know, today's program focuses on the Second Amendment to the Constitution. Now, I would ask you to locate the constitutions which were in your package of materials this morning and take a look at the Second Amendment. It doesn't take very long to read. The Second Amendment says, "A well-regulated militia, being necessary to the security of a free state, the right of the people to keep and bear arms shall not be infringed." That is it. And though it is short, the Second Amendment has been the subject of contentious debate in our country for many years. Advocates of gun control argue that violence in our society can be reduced by passing laws which place limits on the purchase of guns or the type of guns which can be purchased. Gun rights advocates argue that further infringement on the Second Amendment is a slippery slope towards taking all guns out of the hands of law-abiding citizens. The Second Amendment debate is ongoing. Recently in Colorado, 2 Democratic legislators were voted out of office in a recall election. These 2 lawmakers voted in favor of the state's unpopular new gun laws earlier this year, which resulted in the state's first ever recall election. State Senate President John Morse, who was a little more than a year shy of finishing his final term in office, conceded his election after he failed to win enough votes to keep his seat representing Colorado Springs. Also, State Senator Giron of Pueblo lost her seat as well. The new laws in Colorado, which took effect in July, limited firearm ammunition magazines to 15 rounds and required universal background checks on all firearm sales. Now, this occurred recently, the September 10th of this year or so, and again is a reminder to us that the Second Amendment is fiercely debated in our country. Now, we have two excellent speakers this morning, which I have the privilege of introducing to you. The first is Zach Horan, who graduated from West Point in 2006. Following his graduation from West Point, he served in the United States Army from 2007 to 2011, and it included a year's tour in Baghdad. He is now a student at the USC School of Law, where he will earn his JD degree in May of 2014. This past summer, Mr. Horan was a summer law intern at the U.S. Department of Justice in Washington, D.C. Because of his military service and his study of constitutional law, Mr. Horan brings a unique perspective to the Second Amendment issues. Zach, thank you for being here. Absolutely. Our other speaker is David Keene. Mr. Keene is the immediate past president of the NRA, where he served from 2011 to 2013. He was elected to the NRA Board of Directors in 2000. He currently serves on the board of the Constitution Project, which is a bipartisan group which works on constitutional issues and criminal justice issues. In July of 2013, Mr. Keene was named opinion editor for the Washington Times, where he manages the paper's editorial page, commentary section, and online opinion strategy. Mr. Keene is an attorney, columnist, political activist, and lobbyist who has written, spoken, and lobbied on behalf of hunters, shooters, and firearm owners for decades. He has worked in the White House and in Congress and has been involved in nearly every congressional battle over gun control since the early 1970s. Thank you, Mr. Keene, for participating in our program this morning. Now, as you now know, we have two very well-qualified speakers for you today. They will be offering differing views on the Second Amendment. I ask you to please listen carefully, and I encourage you to participate in the question and answer session following their talks. As Mr. Foster told you at the beginning of the program, we are going to ask you to vote on a Second Amendment proposal, or actually two proposals, which will be a part of Mr. Horan's presentation this morning. And we will do that at the conclusion of the question and answer session. At this time, I would like to ask Zach Horan to come forward to make his presentation.
Good morning. My name is Zach Horan, as I was introduced, and I'm a third-year student at the University of South Carolina School of Law. It is an honor to speak to you today, especially because it gives me the chance to talk about our country's Constitution, one of my favorite topics. I would like to start by thanking the South Carolina chapter of the American Board of Trial Advocates for this opportunity, my mentor at the law school, Professor Thomas Crocker, for his guidance and assistance, my wife, Meredith, for her constant support, and my father, Mike, for sparking my interest in our government and its laws. Just a short time ago, I was like most of you, a South Carolina high school student, and it means a lot to me that I get to speak to you today on the important topic of reasonable gun control measures. As a West Point graduate, former Army officer, and veteran of Operations Iraqi Freedom and New Dawn, I am intimately familiar with the importance of skilled marksmanship, the role guns play in our lives and society, and the devastating effects that firearms can have on human life. I hope you take away a few key points today. First, the right to bear arms is a constitutionally protected right, but it does have limitations. Second, the United States Constitution is more than just the words the founders wrote on a piece of parchment over 200 years ago. Our Constitution embodies a rich tradition that we the people must protect at all costs through compromise and cooperation. And finally, third, tyranny in any form is a threat. Yet, the main form of tyranny we face in American society today is the dysfunction of polarized politics and the tyranny of those who would divide rather than unite us through calculated rhetoric. This applies to Democrats and Republicans, liberals and conservatives, interest groups, and elected officials. We have an important job as citizens to see through the rhetoric that divides us in order to find the common ground that unites us. As I prepared for today's event over the last few months, I came to learn one important lesson. There are a lot of things that gun control supporters and gun control opponents can agree upon. There is common ground on this hot-button issue. Wayne LaPierre, the CEO and Executive Vice President of the National Rifle Association, said on NBC's Meet the Press earlier this year, "We want to fix the existing system on retail gun sales because our people are the ones who are going through it and are getting delayed. It doesn't work. Nobody gets prosecuted. It's completely ineffective, and the NRA wants to do things that make people safe." When I heard that, I thought, I agree with Wayne LaPierre's point. As I continued to listen, Wayne LaPierre said, "We want weapons in the hands of criminals taken off the street. I mean, if you're the president and the vice president and the attorney general, and your job is to enforce these laws against I'm talking about drug dealers and gangs and felons that are walking around with guns on the street, and you don't do it, you bear some responsibility. That's a tragedy." Once again, I agreed with the point. Any meaningful gun control measures in the future will have an impact on all Americans because both gun ownership and gun violence are prevalent in our society. Any meaningful gun control measures will impact not only felons and the mentally ill, but also law-abiding gun owners and even those who do not own and will never own guns. Any meaningful gun control measures will raise sensitive issues that we should not shy away from. But the main point is that all or nothing arguments fall short of the mark. I do not endorse a no guns policy because that would be unconstitutional. I do not endorse a no regulations policy because that would be unwise. I endorse common ground. I endorse using reason and compromise and cooperation to solve a problem that plagues our society and impacts our lives as Americans. We cannot solve the problem of gun violence in American society with extreme arguments. We can solve the problem by meeting on common ground. Before talking about the Constitution and the Supreme Court's rulings on the Second Amendment, we need to face facts. First is the fact of mental illness. I start with this fact because it is most familiar to us in the wake of recent high-profile gun crimes involving the mentally ill. As Wayne LaPierre said, the shooters in Tucson, in Arizona, in Newtown, they're unrecognizable. And after Monday's events, we can add the shooting at the Washington Navy Yard to the ever-expanding list of gun crimes committed by the mentally ill. Mental illness does figure into the gun control debate, but it should not be used as a distraction. For instance, an argument along the lines of law-abiding insane gun owners should not be punished because some crazy person shot a lot of innocent citizens is a distraction. It is an us versus them argument. We must remember that the Constitution does not speak in terms of us versus them. The Constitution begins with we, the people. Any solution to needless gun violence necessarily involves addressing the problem of mental illness, but it will also incorporate regulations that affect current gun owners as well. The solution to gun violence will be a multifaceted, multi-front approach to a range of societal issues that casts its net over all the simplistic and neat categories like sane versus insane, criminal versus law-abiding, public versus private, or gun owning versus non-gun owning. Second is the fact that, as the Harvard public health professor David Hemingway writes, the United States has more guns in civilian hands than any other industrialized nation. We have far more handguns per capita, and a gun is easily obtainable by virtually anyone who wants one. This is an overwhelming fact, because it can be used in defeatist arguments. For instance, an argument along the lines of, if a criminal wants to get a gun, they will find a gun on the black market, in the streets, wherever. Or an argument along the lines of, if a crazy person wants to get a gun, they'll get a gun. These arguments should not distract us from implementing changes in gun control over time. This fact should not be used to deter us from supporting the passage of laws that will lead to incremental changes in gun control that will in turn decrease needless gun violence, even if the advances we make are tedious and slow. One of the most important lessons of constitutional law is long-term change. The founders who wrote our Constitution and our Bill of Rights would find American society today virtually unrecognizable when compared to the 18th and 19th century world they inhabited. Some of the founders would probably be quite proud of their creation, while others might be terrified. But more importantly, they would be interested to see just how much constitutional change has affected society. It is rare to have constitutional moments in which massive and sweeping changes occur all at once. Our constitutional and legal tradition is an organic growth that has required over 2 centuries of development to reach its current state, and we cannot blind ourselves to the power of long-term change. Third is the fact of what being a law-abiding citizen means. A law-abiding citizen is not an individual who picks and chooses what laws apply to them. A law-abiding citizen is a person who abides by the laws as they stand. As Wayne LaPierre said, here's what congressional legislators want to do through gun control legislation. They want to take this current mess of a system and expand it now to 100 million law-abiding gun owners. Every time a hunter wants to sell a shotgun to another hunter in Kentucky, every time a farmer wants to sell a rifle to another farmer, legislatures want them to go somewhere regulated by gun control legislation to carry out their transaction. If gun owners are law-abiding citizens now, they must also be law-abiding citizens when gun control legislation is passed. We, the people, as law-abiding citizens, cannot pick and choose the laws we want to follow. If Congress or a state legislature passes a law that is constitutional and does not infringe upon the individual right to bear arms, it must be followed by all citizens, or else our system will not work. And it must be remembered that we have built routes into our legal system that allow us not only to address laws we believe to be unconstitutional, but also to address those citizens who choose not to abide by our laws. Fourth is the fact of current loopholes in acquiring guns. Wayne LaPierre said, "We are working on a bill right now that will hopefully at least get the records of those adjudicated mentally incompetent and dangerous into the check system that applies on dealers. Most of the states still do not even do that. We need to see if we can get that done. We're looking to get better enforcement of the federal gun laws. We're working on laws to beef up the penalties on straw purchases and illegal trafficking, which we want prosecuted. We want to make people safe. That's what the NRA does every day." Now, this is one of the most important facts because I think it ties in directly with gun control opponents' objections to a federal registry of all gun owners, and it shows the importance of federalism in our society. That is, the relationship between the state and federal governments. In my view, closing the loopholes on all transactions involving guns would alleviate the need for tracking individual gun ownership. If the law supports gun transaction background checks, if it assures that only lawful gun owners possess firearms, then we can keep the guns out of the hands of criminals and the mentally ill at the moment of the transaction and direct our federal and state law enforcement efforts to black market and off-market activities, criminal activities, and other issues. We can also allocate more resources to addressing mental illness and gun safety. We will not need to track which individual citizens own guns, and we can avoid distracting arguments like, the government should not invade the privacy of lawful gun owners by creating a federal list of their lawful possessions. A big part of reasonable gun control measures involves attacking the problem of needless gun violence at its source, and that source is manufacture and sales. If we make things safer and more transparent at the source, over time, we can allocate resources to other dangers while decreasing long-term risk. As for federalism, Wayne LaPierre makes an important point. Gun control is not just a federal issue. It is not just a state issue. It is an American issue, and we, as American citizens, must address it together. So let's talk about the Constitution and our laws. This summer, I worked in Washington, D.C. as an intern for the Department of Justice. One Saturday morning, I visited the National Archives to go see the Declaration of Independence, the Constitution, and the Bill of Rights. It was truly amazing to see our founding documents all together in one room, and I highly encourage all of you to make the trip to the archives if you have not had the chance. But, like I said before, our Constitution is so much more than those pieces of parchment. But starting with the words of the founders, I will frame the issues at hand. What does our country's Constitution say about the right to bear arms? And what has the Supreme Court said about the right? The focus of my studies at Carolina Law has been the United States Constitution. Within the first few weeks of my constitutional law course, our class read the Constitution and two recent Supreme Court cases dealing with the Second Amendment. I will refer to the cases by their shortened names, Heller and McDonald. The Second Amendment to the Constitution is brief. We heard it earlier. It reads, "A well-regulated militia being necessary to the security of a free state, the right of the people to keep and bear arms shall not be infringed." Yet, as American citizens, we gain most of our understanding of the Constitution's meaning and limitations from the opinions of the United States Supreme Court. Based on Chief Justice John Marshall's words from 1803, the United States Supreme Court has emphatically concluded for over 200 years that when it addresses the United States Constitution, it is the final law of the land. It is the law we must all follow. The Supreme Court's ability to say what the law is called the power of judicial review. And the Supreme Court explained in its 2008 Heller decision what the individual right of the Second Amendment is and what its limitations are. In other words, the Heller decision stands as the law of the land. In his majority opinion, Justice Scalia pointed out the first interesting thing about Heller, writing that the case represents this court's first in-depth examination of the Second Amendment. Think about that. It took over 200 years before our Supreme Court was called upon to interpret a rather important aspect of our founding document, the right to bear arms. So what did the court say? The majority held that the Second Amendment confers an individual right to bear arms for the purpose of self-defense in confrontations, a core lawful purpose. But the court was careful to note the limitations of the right, stating, the Second Amendment protects the right to keep and bear arms for certain military purposes, but it does not curtail the legislature's power to regulate the non-military use and ownership of weapons. This, according to the court, was the most natural reading of the amendment's text and the interpretation most faithful to the history of its adoption. In other words, the Supreme Court told legislators, our elected representatives, that they have the power to regulate the non-military use and ownership of firearms by passing laws. Strongly basing its opinion on the historic militia aspect of the amendment, the court found an individual right to bear arms for all citizens capable of military service who would bring the sorts of lawful weapons that they possessed at home to militia duty. The key words here are lawful weapons. In Heller, the court noted important limitations for the right to bear arms, giving Congress the ability to enact reasonable gun control legislation that would be lawful in the eyes of federal courts because it would not infringe on the constitutional right to bear arms. Like most rights, the right secured by the Second Amendment is not unlimited. Nothing, in our opinion, should be taken to cast doubt on longstanding prohibitions on the possession of firearms by felons and the mentally ill, or laws forbidding the carrying of firearms in sensitive places such as schools and government buildings, or laws imposing conditions and qualifications on the commercial sale of arms. The sorts of weapons protected are those in common use at the time. We think that limitation is fairly supported by the historical tradition of prohibiting the carrying of dangerous and unusual weapons. In other words, the Supreme Court emphasized in Heller that dangerous and unusual weapons can be prohibited through laws, amongst other important limitations. The other recent Supreme Court case dealing with the Second Amendment is McDonald. Justice Alito, writing for the majority, stated, "The due process clause of the 14th Amendment incorporates the Second Amendment right we recognized in Heller." What this means is that neither the federal nor state governments may infringe upon the Second Amendment right to bear arms. In sum, the Supreme Court has given us 3 important lessons on the Second Amendment in the last 5 years. First, the right to bear arms is a constitutionally protected individual right for the lawful purpose of self-defense. Second, the right to bear arms has limits. Legislatures may regulate the right to bear arms by prohibiting the possession of firearms by felons and the mentally ill. Legislatures may regulate the right to carry arms in sensitive areas like schools and government buildings. Legislatures may regulate the commercial sale of arms, and the right to bear arms is limited to those weapons in common use that are not dangerous and unusual. The third and final lesson is that the right to bear arms may not be violated by either federal or state governments. Now let's talk about some of the problems posed by avoiding reasonable gun control measures. This is where most discussions about gun control and gun violence run off the rails, because sometimes we like to point fingers without providing solutions or really addressing the issue. As the Harvard public health professor David Hemingway writes, people should be held accountable for their actions. Such responsibility pertains not only to the behavior of gun users, but also to the conduct of gun owners, gun carriers, gun manufacturers, gun distributors, public officials, and other decision makers. However, the goal is not to find fault, but to prevent injury and death. Those are the problems. A lack of public and private accountability, as well as injury and death in American society. Without railing against law-abiding gun owners, without focusing solely upon felons and the mentally ill, without speaking in oversimplified us versus them or all or nothing terms, the problems involved with avoiding reasonable gun control measures can be identified more easily. One of the best lessons I learned from my time in the Army is that if you're going to point out problems, you better provide or offer some solutions. As I said from the beginning, there's a lot that gun control opponents and gun control supporters can agree upon. My proposals seek to fall within common ground that we can all support. First, universal background checks should be made a reality. These background checks would apply to all transactions involving the transfer of firearms. In other words, whenever a person wants to get a gun, whether at a gun show or from a neighbor or from an authorized dealer, they must first have a background check that allows them to get the gun. These checks would close loopholes that allow guns to move through our society where they can fall into the hands of those who should not have them. As anyone who has used a firearm knows, Guns are unforgiving tools, but they can also be fun to shoot. And they can be used to protect our families, our fellow citizens, and us. Making universal background checks a reality would allow us to respect the constitutionally protected right to bear arms, while also recognizing the inherent danger involved in a gun-owning society. Second, as Wayne LaPierre said, we want to make people safe. That's what the NRA does every day. Like I said before, I agree with this idea. And if both American citizens and the NRA want to make people safer, I think we can accomplish this crucial goal by holding gun manufacturers accountable for the products they create, making sure that their weapons have the proper safety features that deter accidents amongst adults and children, by making sure that the weapons and magazines they produce do not fall within the category of dangerous and unusual weapons. For example, recent legislative proposals have focused on limiting magazine capacity to 10 rounds rather than 30 or 100. High-capacity magazines are dangerous and unusual tools that allow shooters to fire massive amounts of rounds without reloading, and they must be regulated. A regulation on high-capacity magazines would still allow lawful gun owners the ability to serve in their important militia capacity, if the need ever arises, while also limiting the ability of criminals and the mentally ill to unleash unbelievable firepower on innocent citizens and law enforcement personnel. We can make people safer by holding sellers accountable, by lawfully regulating the commercial sale of firearms. We can make people safer by holding citizens accountable through gun safety and awareness programs like those the NRA supports, and by regulating transactions between them in order to make sure that only law-abiding citizens have access to firearms. We can make people safer by holding health professionals accountable, by allocating resources to address mental illness, and raising awareness of the dangers of gun violence by incorporating statements about the possible risks of gun ownership into the day-to-day conversations health professionals have with their patients. We can make people safer by holding public officials accountable through stronger federal and state law enforcement and prosecutions, through supporting reasonable gun control measures, through our own involvement in our nation's democratic processes, and, in light of Monday's events at the Washington Navy Yard, through more effective background checks on government employees. I will close by saying that we understand ourselves and our laws and our society through dialogue. This dialogue could be a conversation at the dinner table, in the classroom, or a letter to your congressman. But no matter what form it takes, this dialogue defines who we are and what we think. If we choose to sit on the sidelines in silence, others will gladly control the conversation for us. With that in mind, I want to pose a few questions for you to consider in the days ahead after you leave this room. First, how can we be satisfied with elected representatives who are so easily swayed by threats to their positions in office? When an overwhelming majority of American citizens, gun owners and non-gun owners alike, favor reasonable gun control measures like universal background checks and laws against high-capacity magazines, the threat of losing the next election or campaign funds should not lead our elected representatives to vote against the will of the people. As I noted earlier, gun violence is not a federal or a state issue. It is an American issue. There are some things that can be categorized as purely local problems, but gun violence is not purely local. Remember, all of our elected representatives, state and federal, swear an oath to the United States Constitution upon taking office. And in the preamble of that document mentioned earlier, it states that the Constitution was created to promote the general welfare. That is the well-being of the American people, us. Our elected officials should bear that in mind when making decisions that affect us all. Second, how is it that oversimplified messages and dangerous rhetoric can continue to thrive in our national dialogue when reasonable gun control measures necessarily involve all Americans, not just neat categories of people. It is incumbent upon us, as citizens, to inform ourselves of the complicated facts that will lead to the reality of reasonable gun control. This means reading the news, reading books, reading scholarly articles, writing elected representatives, talking to our fellow citizens, and voting, like you will do later today. This means taking control of our country's course on gun control, rather than turning control over to those who would divide us by polluting our national dialogue and distracting us from the common ground that unites us. Third, bear in mind that my message today has in no way endorsed a solution to gun violence that completely eliminates guns from the equation. So what can we do at the national, state, city, and community levels to curb the threat of unnecessary gun violence? I hope that some of the proposals I put forward provide a starting point to answer that question. At the end of this summer, when I traveled home from Washington, D.C., I drove right past NRA headquarters in Fairfax, Virginia, and thought about this speech. I wondered what I would say, how I would start, how I would finish. I will finish by saying that I think we have an unquestionable right to bear arms within the limits of the law. I think that as the Supreme Court decided, the federal and state governments are constitutionally obligated to respect that right. I think that we are smart and reasonable enough to decide what dangerous and unusual weapons are through our democratic processes and national dialogue. I think that universal background checks are not unreasonable. I think that no hunter or sportsman or marksman or citizen seeking to protect their families in the home or citizen seeking to protect themselves in a public place has a need for a weapon with fully automatic capability or a high-capacity magazine when there are so many other firearm options available. I think that the only tyranny this country faces is the dysfunction that comes from polarized political positions, the manipulation of the Constitution's text and historical evidence, and oversimplified rhetoric. I think that the way forward is through common sense and common ground. I think that we are all responsible for moving us forward, but more specifically, that you will be responsible for moving us forward. And I have all the faith in the world that you will take that responsibility seriously in the years ahead. I'm more than happy to answer any questions about West Point, the Army, my deployment to Iraq, or Carolina law during the question and answer session. Thank you for your time and participation in this event. I look forward to seeing what all of you do after high school as you become the future leaders of our state and of our country. It was a pleasure talking to you today.
Thank you very much, Zach, for framing the issue. Next, David Keene from the NRA.
Thank you very much. It's a pleasure to be with you today, particularly as part of a program dedicated not just to the Constitution, but named for James Otis, a man that, as was indicated earlier, John Adams once credited with laying the philosophical foundations that led to the American Revolution and establishing the country that we live in today. The study of history and of our Constitution is important, not simply because to some of us it's interesting, but because it's vitally important to the preservation of the values that have made the American experiment possible and that allows us as a people to claim to be beneficiaries of what many call American exceptionalism. You know, today, the Constitution is ignored by many in discussing public policy. It's as if it didn't matter. And I often say that the dark sort of underbelly of domestic view of American exceptionalism is that we got to where we are because of who we are. That's in part true. But the country we live in today is the country that we live in today because of what happened when the founders sat down to decide how to create a republic that could perhaps survive, that would not turn into a tyranny, that set up the checks and balances, that set up the separation of powers, that guaranteed ultimately that the government could not interfere with certain rights of the citizens that the government was set up to provide services for. That was not an accident. Our survival has not been an accident. It's been traceable. It is traceable directly back to the institutions that were formed as a result of the writing of our Constitution. And the Constitution and what they did then is as relevant today as it was then. And in fact, James Otis is a perfect example of that. He may have laid the philosophical basis for the American Revolution, but he is certainly can be described as the father of the Fourth Amendment, which was later incorporated into the Bill of Rights. And think about the earlier description of the kinds of challenges that he fought. And then think about today. Think about the argument over the Fourth Amendment and the right of the government in the name of security to collect more data on Americans, on their phone calls, on their emails, and on their private lives without a warrant, without cause, than we've ever experienced in the past. All I can say about James Otis is that if he were alive today, he would not make the Christmas card lists of the President of the United States, the Attorney General of the United States, or Jim Clapper, President Obama's Director of National Intelligence. But I'm charged today not with a discussion of the Fourth Amendment or the Constitution in general, but with a discussion of the history and relevance of the Second Amendment and the Bill of Rights of which it is a part. In the recent struggle that the NRA and gun owners in general faced in the United States Senate, in the final days of that debate over what was called a universal background check, the American Civil Liberties Union came into the debate on the side of the Second Amendment and on the side of the National Rifle Association, its members and gun owners across the country. And I talked to one of the officials of the ACLU because it's the first time that they'd actually done that. And they said, you know, we've sort of come to the conclusion after several decades that the Bill of Rights is not a smorgasbord. You can't say, I'll take two of these and none of those. That maybe what you have to do is accept it or reject it in total. That became very clear during the course of the debate at the state level and the national level over the Second Amendment during the course of the last year. In Washington state, legislation was almost passed that would have said that in the area of Second Amendment or gun rights that the Fourth Amendment did not and does not apply, and would give authorities in Washington state at any time the right to go into any home and search to see if there was guns, firearms in that home, regardless of whether the individuals living there were part of a prohibited group. That sounds very much like what James Otis was dealing with so long ago. The Second Amendment and the Bill of Rights were ratified in 1791 as a result of a demand by many that the Constitution include written specific guarantees that certain rights could not be violated by the federal government, and that it had to be written as it wasn't in other countries. The Congress met after the Constitution was passed and considered more than 100 possible amendments. 12 of them were finally adopted by Congress. 10 of them that became the Bill of Rights were ultimately ratified by the states. They were the ones that were the least controversial. They were the ones that, regardless of whether the Federalists thought they were needed or not, or whether the Anti-Federalists wanted something else, they were the ones that substantively virtually everyone agreed on. It's interesting that the Second Amendment was second. As they listed those, the First Amendment guaranteed the right to worship as we please, the right to petition our government, the right of a free press, and the right to speak. And the Second Amendment guaranteed the right of Americans to keep and bear arms. That was an uncontroversial amendment at the time. It was an uncontroversial amendment for a long time. I'm going to talk a little bit about the history of the National Rifle Association because it's intimately bound to the development of thinking about the Second Amendment. The NRA was formed in 1871. This is a speech I usually don't give in the South. It was formed by a group of Union generals who believed that the Civil War had gone on for too long because Northern troops didn't know how to use firearms. When the Civil War began, the South, the Confederate States, were drawing their troops from people who'd been in the country for generations, who understood firearms, who used them, who carried them, and who know what they were doing. The North, first as volunteers and then by draft, was getting people from the newly industrialized cities of the Northeast, New York, and the like. Many of these people did not fire a gun until they got on the battlefield. They came from Europe with no firearms tradition. They didn't have training. They were just put out in the field with a gun and said, this is your job. And the common wisdom at the time was that a Confederate soldier was the equal of 3 Union soldiers, because the Confederate soldier knew how to use firearms, the Union soldier did not. Unfortunately for the South, there were 5 Union soldiers for every Confederate soldier, so in the end it didn't make much difference. But the NRA was formed because, interestingly, Northern generals at the time, after the war ended, believed that we were losing our firearms tradition because new people were coming into the country who didn't understand it, and that they needed to have training, safety training, arms training. They needed to come to appreciate what firearms had meant to America. 2 of the first presidents of the National Rifle Association were Generals Philip Sheridan and Ulysses S. Grant. And between 1871 and 1970, the National Rifle Association had no advocacy arm. The NRA didn't endorse candidates. We didn't lobby Congress or state legislatures. We didn't do any of that for the simple reason that it wasn't necessary, possibly for the same reason that during that period, the Supreme Court only mentioned the Second Amendment in decisions 6 times, 5 times in passing in the 19th century and once in the 20th century. There was general agreement that the articulation of the meaning of the Second Amendment that was finally made by the Supreme Court in 2008 in the Heller decision that was referred to earlier was what the Second Amendment was all about. That began to change at mid-century. It began to change in 1968 as it became a more ideological, symbolic, and partisan issue in this country between the parties. Prior to that time, life members of the NRA had included everybody from Teddy to Franklin Roosevelt to Dwight Eisenhower and Hubert Humphrey, liberals of the day. John Kennedy was a life member. After that time, things began to change. The NRA got involved in political advocacy because a Democratic congressman from Michigan, who happens to still be serving, John Dingell, a very partisan Democrat, came to us and said, you can train all the competitive shooters you want, you can run all the competitive matches you want, you can provide all the safety training for shooters and hunters and the like, and none of that's going to matter because the Second Amendment is under assault, and if you don't step to the fore and do something about it, nobody is going to have a right to keep and bear arms for any purpose. And during that period, some 20,000 laws across the country, local laws, state laws, federal laws, were passed restricting firearms use and ownership. In 1970, the new president, the Republican president, the Gun Control Act of '68 had been passed by a Democratic administration, but the new president, Richard Nixon's Attorney General, announced a plan that would result in the confiscation of all privately owned sidearms by the 1980s. Anyone who was alive at that time and who saw what was going on probably wouldn't believe the extent to which gun ownership has been legitimized in the years since. Today, in all 50 states in one form or another, citizens have the right to have a concealed carry permit. Different states have different regulations, different rules, look at it differently, but all states have to. Last week, the state of Illinois and its Supreme Court, and Illinois is not the most Second Amendment-friendly jurisdiction in this country, ruled 9-0 that the right of self-defense could not be restricted to the home. Remember, previous cases had involved whether you could have a firearm in the home. The Second Amendment, when it was adopted for a variety of reasons, but as the court in 2008 said, the right to self-defense and the right to possess a firearm for the purpose of self-defense was not something that was granted to the American people by the Bill of Rights, that it was the recognition of a pre-existing right that Englishmen and others had. In fact, the right to self-defense and the right to arms had been discussed as far back as Plato and Aristotle. It was included in the rights of Englishmen, the Bill of Rights of Englishmen, and in other nations. So it was recognized, as were other rights. And it's interesting and it's important to recognize that as you read the Bill of Rights in a number of areas, the government did not grant American citizens the right to speak freely. The government recognized the right of the people to be able to speak freely. The government recognized the right of the people to keep and bear arms. But it wasn't until 2008 that a case went to the Supreme Court, originating in Washington, D.C., one of the least gun-friendly jurisdictions in the country, that the court actually looked at the history and the meaning of the Second Amendment and decided that, yes, indeed, the founders actually meant what they said when they drafted the Second Amendment to the Constitution, and that it does, in fact, guarantee individual citizens the right to own firearms, in this case, in their home, to protect themselves and their families. And specifically, it was related to sidearms, a pistol that a retired special police officer wanted to keep in his home for his own protection. The Heller case, which was referred to, and that's the case I'm talking about, recognized that right in a federal city. And to go back a little bit and look at the Bill of Rights, you know, initially it didn't apply to anything except the Congress. Think about the First Amendment. Congress shall make no law. It didn't apply to the states. It wasn't until after the Civil War and the adoption of the 14th Amendment that the courts decided and began to, what they called, incorporate portions of the Bill of Rights so that they did, in fact, apply to state action as well as congressional action. And interestingly, the debates over the 14th Amendment after the Civil War, much of the debate related directly to the Second Amendment. Because one of the things that happened when the Civil War closed and slaves were freed was that in some states, attempts were made to make certain that black Americans would not have a right to have firearms. In fact, here in South Carolina, the legislature passed laws denying firearms to black citizens. And the Assembly sent to the Congress and issued a statement that was read into the record in Washington. It said, "We ask that inasmuch as the Constitution of the United States explicitly declares that the right to keep and bear arms shall not be infringed, that the late efforts of the legislature of this state to pass an act to deprive us of arms be forbidden as a plain violation of the United States Constitution." And that debate was going on, and when the 14th Amendment was passed, it was in large measure to make certain that these newly freed citizens had the same rights that other citizens had. And interestingly, when we got to the McDonald decision, which was a decision involving the city of Chicago, which argued that they could do whatever they wanted in terms of gun control because they weren't a federal enclave and that the Second Amendment didn't apply to the states, they argued against incorporation. The Supreme Court said no. History, what's happened with the Second Amendment, means it applies as much to what you do as it does to what's done in a federal enclave like the District of Columbia. And at that point, the world changed. I went to law school in the 1970s. And I don't think anybody ever mentioned the Second Amendment in any class that I was in. In the last year, I've gotten numerous calls from law schools saying, "Do you know somebody that could be an adjunct professor to talk about Second Amendment laws?" because the Second Amendment is now in the place that the First Amendment was in the 1920s. A body of law will develop which will outline what is and what is not permissible in terms of state regulations of firearms ownership and use, just as a body of law developed about what kinds of regulations could be applied to speech. Every right in the Bill of Rights is subject to limitations, and that was recognized, as Zach mentioned, by the Supreme Court. He got a little bit wrong, but people always do. The court argued that, among other things, one could not ban a weapon that was widely owned and commonly used for legitimate purposes. I always thought that the majority put that in there because they thought Dianne Feinstein was still drafting so-called assault weapons bans. Because the AR-15, which is the gun that the anti-gun folks hate so much that they tried to put it into the hands of the killer in Washington last week, even though he'd never used one, didn't have one, hadn't bought one, is owned by 4.5 million Americans, and it's widely used for self-defense. It's the platform most widely used for firearms training and marksmanship. It's used for predator hunting. In many states, it's not used, not allowed for big game hunting because the .223 is too small. And I almost thought that they wrote that because they were saying they're going to try this again. They tried it before. Let's just tell them it's not going to work. When you're talking about a fundamental right, obviously restrictions have to be looked at and scrutinized by the courts carefully. And while restrictions can be legitimately placed on such a right, they have to be drawn narrowly to accomplish a purpose without interfering with the rights of others. For example, although I mentioned earlier 50 states have so-called concealed carry laws, some of them have what are called shall issue laws, and that is, if you want to carry a firearm, you apply to the state, and unless they find that there's a reason that you shouldn't be allowed to carry that firearm, you're a felon or a number of other things, you've been adjudicated to be potentially violently mentally ill, they have to issue that permit to you. Other states have what they call may issue laws, in which you go to the sheriff and he decides, or some official decides in their judgment, whether or not you should be able to do that. That's obviously subject to political influence on the one hand. For example, in Maryland, which is a may issue state whose law was struck down by the federal district court, because in Maryland you have to be able to prove, or had to be able to prove, that your life was in imminent danger. And the federal court said that you cannot force a citizen to prove that he has a right to exercise a right. If you want to deny him that, it's the state's obligation to say there's a reason why he can't. And so that was struck down. But those kinds of laws are subject to political interpretation and political pressure. The state troopers who were in charge of issuing these permits, one of them told one of our people who was having trouble getting one that his life was being made miserable because he'd gotten calls from Senator Feinstein because one of her aides wanted a concealed carry permit, and she said, you will issue it. So political pressure comes in when you have the ability to decide who gets to exercise rights and who doesn't. But with the passage of these laws, of these cases, I should say, things began to be looked at very differently. There are now hundreds of lawsuits around the country which are going to address the question of what is and what isn't legitimate. In Maryland, finally, they backed off a little bit in this current wave of state laws, and the governor had proposed a package of laws that would have added something like $500 to the cost of a sidearm if you wanted to purchase one. And finally, the legislators from Prince George's County, which is a majority black and poorer county, the county I live in, said, well, wait a minute. It seems to us that these laws are designed to guarantee that people in Potomac, Maryland, the wealthiest part of the state, can have firearms, but our constituents can't because they can't afford them. And that's no different than licensing for speech. And we don't know at this point what can be charged. Can Can you charge a citizen the actual cost of doing a background check? Or can you add on all these other things and then put the money into the general revenue? At some point, the tax becomes an unreasonable restriction on a fundamental right. These are all things that are going to have to be decided by the courts. But you know, as you look at the policy arguments that are going on, and many of them are symbolic rather than real. We just had a debate that went on for some months. The President of the United States and others tried to portray this country as awash in blood and violence as a result of firearms ownership. In fact, homicides by firearms, people being killed in this violent way has been dropping significantly by 40% over the last few decades, while at the same time, firearms ownership has gone way up. There are now 300 million estimated firearms in private hands in this country. 43% of all families have a gun in the house. Accidents, in absolute terms, are lower today than they were in 1916. That's partly something that the NRA is very proud of, because most of our effort goes into safety training, competency training, how to handle a gun, how to store a gun, what to do with one. You're more likely, according to the U.S. government, for your child to drown in a bucket of water in the kitchen while you're cleaning the kitchen than you are to have he or she die in a firearms accident. They don't occur in any statistically significant way. We're told that mass killings are on the increase. In fact, statistically, they're not. I appeared in the midst of this, and this is something that Zach can relate to, on the Face of the Nation back in January. Bob Schieffer, the interviewer, said, you know, I pointed out to him that gun deaths, firearms deaths were much lower than they'd ever been. He said, well, that's just like Iraq. It's because more people are being shot, but our medical system saves them. And I hadn't seen any figures on that, so I worked around it. 3 weeks later, the federal government came out with a study through the Justice Department that said woundings over the last 10 years were down 70%. Not only were homicides down, but fewer people were being shot without being killed. And that was simply a figure that was made up. Many of these things, many of the statistics that are used, many of the examples that are used, just don't hold water. The debate that we had, and this goes to Zach's proposals, over the so-called universal background check, which is a misnomer in a sense because no one, including the President or Michael Bloomberg, has ever suggested such a thing. They have suggested expanded background checks and pointed out quite accurately that the National Rifle Association supported the establishment of the National Instant Check System because there are people who should not be in a position to purchase a firearm. That includes convicted felons. It includes groups. It includes those who are adjudicated to be potentially violently mentally ill. It doesn't include people who get psychiatric counseling. It doesn't include people who have a bad day. It includes those people who are potentially dangerous. In 1993, our Executive Vice President, Wayne LaPierre, who Zach mentioned, was on national television with then Congressman Chuck Schumer. And he pointed out that most states were refusing to submit records on those who've been adjudicated to be potentially dangerous to the national system for checking. Congressman Schumer got up, shook his hand, and said, Wayne, I can help you with that. We can work together. That was 1993. Today, 23 states don't do it. We just had an example of the shooter in Washington at the Navy Yard, who was stopped by police in Rhode Island, who told him he was hearing Martians or something, talking to him. He was clearly had clear schizophrenic tendencies and symptoms. The police did not have the power under our current mental health rules to involuntarily hold him. Even if they had, it wouldn't have mattered, because of the 50 states, the state that is least likely to report someone who's adjudicated to be potentially dangerous, the 50th state is Rhode Island, which just refuses to submit that information. So what did the police do? They called the Navy, and they said, we think this guy's crazy, and he could be dangerous. And whoever they talked to said thank you and hung up the phone. That was the end of that. And of course he was. I sometimes stop the story with Chuck Schumer being unable to help us do something about that, but actually it went on because there was a meeting in the Senate in the mid-90s to talk about correcting that part of the background check system. And then Senator Kennedy burst into the meeting and said, you will not place any of these people in the system because you're not going to demonize the mentally ill. And since then, that's become an ideological question. And every single mass shooting has involved people who are violently mentally ill. And in each instance, somebody, in many instances a gun dealer or a range owner, has been the only person who's recognized that and called it in and said this person is somebody that something needs to be done about, but nothing has ever been done about it. The President of the United States, talking about the current system, and the reason we supported it and don't support its expansion is, one, because many people aren't on it, and two, because many people who shouldn't be on it are. If you're convicted of a felony, you do not, under federal law or state law, have a right to purchase a firearm. There's nothing wrong with that, because we think you shouldn't. And yet many states don't put those records into the system. And other states put simple arrest records into the system, so that even though you may have been arrested for something, never convicted or acquitted, you go to buy a firearm and you've committed a crime because you're a prohibited person. The President of the United States suggested during his speech that 2 million people who shouldn't have firearms were prevented from having firearms by the current system. In fact, 98% of those were what they call false positives, being confused with somebody else, being in the system and not supposed to be in the system. Interestingly, last year, I think it was, 8 people were prosecuted out of 90,000 that were denied firearms, because they were the only ones they could find who'd actually done anything that was prosecutable. One of them was a fellow who in 1940s, while he was in college, had stolen a 6-pack of beer and had been arrested. Wasn't a felony. He'd forgotten all about it. He went to purchase a gun 50 years later or more and was arrested because that state had put that record, that arrest record, into the system. And as far as the feds were concerned, he was a felon, and they prosecuted him. Those are the kinds of things that are not allowable under the Constitution. And when we talk about restrictions, the President likes to talk about gun violence. There are 2 kinds of gun violence. One, the kinds of things that occurred at the Navy Yard, where you've got somebody who has a mental problem, a serious mental problem, who hasn't been reached, treated, or otherwise dealt with. And you have gun crime, such as you have in Chicago. Gun crime committed by criminals who in many cases are criminals who have been arrested previously for committing crimes. In Chicago, if you're arrested committing a crime with a gun, according to the police there, you can be back on the street in 3 weeks. The President talked about a girl that had attended the inauguration and was killed in a drive-by shooting in Chicago. She was killed, by a thug who was out after shooting someone else. Gun crime can be dealt with by prosecuting gun criminals, not by going after others. But in Chicago and in a few other jurisdictions, they don't do that. There are 89 jurisdictions in the country, federal jurisdictions. And guess which one is 89th in the prosecution of gun crime? It's Chicago. So there are things that can be done, and there are things that should be done. But none of the things that should be done can be used or should be used as an excuse to interfere with the fundamental rights under the American Constitution of the American citizen. And the National Rifle Association and most citizens, it's happened in Colorado, it's happened elsewhere, will stand up for those rights when they're threatened. They should stand up for them. You should stand up for them because they're fundamental to the country as designed by the founders and as it exists today. I want to end with one brief story. About 10 years ago, in Moscow, there was a dinner. I guess it was 13 years ago now, given his age. There was a dinner honoring General Kalashnikov. General Kalashnikov is the man who, during the course of World War II, invented the AK-47. Russia doesn't have many heroes these days because they had 70 years of trouble. But General Kalashnikov is one of them. He's still alive. At that dinner, Mr. Putin gave the toast. And when he finished, General Kalashnikov stood up, held his glass of champagne up to him and said, "Mr. President, I have a dream of a country like the United States, run by men and women not afraid of an armed populace." And he sat down. And I ask people when I think about what happened there in that remark, that's the country we live in. And it's the country that other people can only dream about. It's what makes America unique. This is a country in which people are free and the government cannot, because of our Constitution, take those freedoms away. And it's our obligation as citizens to make certain that the country we live in today is the country that we pass on to future generations. It's that important. And that's why I'm so happy to be here with you today to observe the importance, not just of the Second Amendment, not just of the Bill of Rights, but the country created by the Constitution that we live under. Thank you very much.
Mr. Keene, thank you very much. And what happens is we never know how long the presentations are going to go, but clearly these two keynote presentations were the most important part of this program. This is what we're going to do. Dean Wilcox will be up here for any of you aspiring law students to ask him some questions afterwards. Our two presenters will be up here if you have any specific questions, but we simply don't have time for the question and answer because we'd like to vote and we'd like to give out scholarships. So this is what we're going to do. Is Patty, are you around here, Patty? If everyone could quickly vote, and then while you're voting, Sam Mountain and I will pick the scholarship winners, but go ahead and vote and pass your ballot to the end of the aisle when you finish voting, and we're going to go ahead and pick our scholarship winners. Thank you so much to the two presenters, and believe me, I would rather have these presentations than even the questions and answers. I mean, I have 100 questions.
We filibustered to avoid
They filibustered. They filibustered.
It was a joint effort.
So we had a joint filibuster, which is just fine. That was great because the presentations were so good. But please come down here and ask them after. Okay, so here's what we're going to do. As you all are voting, we will, Sam, why don't you record, why don't you pull the name out of the hat, or I'll pull the name out of the hat and you be my, okay. All right, so we got two winners right off the bat. Okay. The first winner from Lexington High School, Christopher Reed Tidwell. Reed, are you here? Come on up. Automatic winner. Do you know where you're going to college yet?
South Carolina.
Okay, thinking about Furman, but USC honors, USC. Okay, so we got a potential winner here. All right, number two winner from White Knoll High School, Philip Tyler Brown. Is Philip here? All right, coming down, Philip. Where's Philip?
He's coming down.
Oh, he's coming down. Okay, good. Philip, do you know where you're going to college?
Well, my teacher kind of messed up. I'm a junior.
Oh, you're a junior.
Yeah.
Good. Okay, well, you got another year to decide where you want to go to college, but you are our second recipient. Okay? Now, the two alternates, in case either one of these gentlemen do not decide to go to South Carolina, the first alternate from Spartanburg Day School, Matt Henderson. Matt here? Come on down, Matt. Matt, your job is to convince one of these two guys not to go to South Carolina. Okay, thank you very much. All right, and then the second alternate from St. Joseph's, Danny Leon. Danny Leon? Danny here? Is Danny Leon here? Oh, she's coming. Okay, good. All right, so that's our, Danny will be our second alternate. Congratulations, you got to convince two people not to go to South Carolina. Okay, well, thank you very much. You all please stay in touch with Patty Kavanaugh and materials. Let her know what your plans are, because these other two people may have some interest in your college. Okay, thank you very much. All right. Now, are we ready for the vote? Patty, are y'all collecting the votes still?
Yes, we just finished.
Okay.
Okay, is there anybody else?
Yeah, that's right.
Okay, is that it?
All right, as Patty is, Patty, as soon as you get the tabulation, just bring it up front. In the meantime, I mean, we've got a couple of minutes here while she's gonna do the tabulation. Does anyone have a question they want to ask either Dean Wilcox about law school, anything about the guns? It's the University of South Carolina, and it's undergraduate. It's undergraduate. Right here.
I have some questions about the gun argument. When Mr. Keene said that they should enforce or make a law for universal regulation.
Background checks.
Background check. How exactly would you enforce that?
And how would you enforce universal background checks?
Well, I would. And I did say though that no one has proposed that because even the president said most private transactions involve family members passing, and before these current rules were adopted, there were indictments of fathers turning guns over to their son under the '68 Act. That was all taken out of it because that's not the kind of people they went after. A universal check would require that everyone, fathers and sons, grandfathers and granddaughters, be checked before they could receive a firearm. You think that won't work? Current system doesn't.
Zach, what kind of universal background check are you proposing?
Yeah, I think that just getting expanded the other percentage that is not regulated right now, about 40%. Just getting into the fine grain of that. Some things are going to be very, very difficult to regulate, like for instance, gifting within families. But there was a recent executive order, for instance, like you can't donate weapons to a trust, which is a way that this was avoiding background check. It's not going to be instantaneous. Again, this is going to be long-term change, and I think it will take time to get into the fine grain regulation of it.
And I think one thing that Mr. King talked about, for the NRA and the ACLU to come together on the same platform, they oppose these the universal background checks because they felt like it would infringe on
The reason for that, if I could just take a second, is that we had alleged, and the Justice Department had Zach, I just want to throw out something for your further research. The 40% figure that you got is from a study that was done, a telephone survey before before the NIC system was put into effect. And even under that study, only 4% of sales, private sales, were arm's length sales. Most of them were family sales. So those numbers were discounted at the time and are even more discountable now because that was before they had the instant check system.
So I think what you're seeing is that not only is this highly controversial, but the practicalities of it is why no one can just snap the finger and all of a sudden we've got a sweeping constitutional change. Okay, while I'm waiting for the vote count, right here.
All right. In the subject of mental illness, you want to avoid falsely accusing someone of being mentally ill when they're really not. So, do you think you can provide a definition of someone who is a danger to others?
Let me give you, if I may, an example of the kind of thing that can happen. Dianne Feinstein has said that every veteran is crazy and shouldn't be allowed to have a firearm. That would include Zach, and I don't think he is. During the Clinton administration, any veteran who had ever had counseling, 69,000 of them, were placed by executive order into the prohibited category. We went to Congress and got that reversed. Our position in this case is similar to the ACLU's position. That is that there needs to be an independent adjudication that you're potentially dangerously mentally ill. Not that you had a bad day, not that you've got depression, not that you're taking a drug prescribed by a doctor, but that you're potentially dangerous. And there has to be a way then to go back, presumably if it's a mental health problem, a lot of it can be cured, obviously some can, so that your rights can be restored. You can't simply take away someone's fundamental rights because you don't like them or because you don't like the way they act. There has to be a way to demonstrate that they are in fact a danger to themselves and to society.
Okay, one question, young lady.
I know that you talked about a little bit of the gun violence in Chicago and how they have the ban on firearms. So I would love for you to elaborate a little bit more on that, and then also for the other speaker to maybe talk a little bit about his view on Chicago's ban on firearms.
Let me give you an example. As I said, of the 89 federal jurisdictions, Chicago has fewer prosecutions than any other jurisdiction in the United States. If you rob a 7-Eleven, you've committed a state crime and a federal crime. It's a federal crime to commit a felony using a firearm. In the 1990s, the murder capital for a time in the United States was Richmond, Virginia. And the NRA went in and partnered with the U.S. Attorney, the police, and prosecutors in Richmond and created something called Project Exile and publicized it. And the line was, commit a crime, use a gun, go to jail. Within 2 or 3 months, the murder rate with firearms dropped 60% in Richmond because criminals knew that if they were caught with a firearm, if they were a drug dealer, if they were somebody who was already a felon, if they were caught, they went away for 5 years. And there were no exceptions. And they were prosecuted. The Justice Department at the time, the Deputy Attorney General, a fellow by the name of Eric Holder, tried to discipline the U.S. Attorney because he said, we do not go after guppies. Those are the criminals who use firearms. We're only after a change in gun policy. So it is demonstrably true that if what you do is prosecute people who break the law, that you reduce crime. And that's what's not happened in Chicago. There's a reason for that. And it goes back decades. The difference, we have two sort of groups in the society, and I'll say for the NRA, we believe people are responsible for what they do. And then you've got folks who don't believe that. In Chicago, you've got a sort of governing philosophy that the criminal did it because there was a gun there, he did it because his potty training was wrong, he did it because he was poor, he did it because his mother mistreated him or the like. And therefore, we have to blame something other than the criminal. And in those jurisdictions, and there's still a few left, Chicago being the prime example, gun crime simply is not prosecuted.
And then you said you wanted Zach to address the Chicago?
Yes, sir.
Do you
Yeah,
know-
my answer will be a bit more succinct. Number one, I agree with stronger federal and state prosecutions, as I said, and also the McDonald decision, the one that made the Second Amendment rights in Heller applicable against the states as well. It covers it. And Heller specifically addressed handguns. So those are my views.
All right, we'll take one last question and then we got to vote, but let's, right here.
I have a question for Mr. Warren.
Yes.
You proposed the universal background checks. Who would pay for that? Would it be a tax? Would it be the making of the sellers, or would it be put in the price of what?
Yeah, I think a lot of these problems, and it's kind of like a tenet of investigative journalism, just like follow the money. Like, where is the money coming from? For advocacy and politics, what politicians are getting the support of this advocacy, and a lot of the money comes from manufacturers. So, yeah, put it on the price.
What percentage of our budget do you think comes from gun manufacturing?
I'm not qualified to talk about that, and I won't.
About 3%.
What we're going to do is, since I don't know, I think we're out of time, and so please come forward and speak to any of the speakers. But we do have a verdict, and you, the people, after hearing the debate, you have decided what you want to do within your communities about gun control and gun rights. Question number one: universal background checks required for all transactions involving the transfer of firearms. Yes, 56, no, 19. So you all have just passed universal background checks. Now, I don't know how you're going to pay for it, and I don't know how you're going to do it, but you all just passed that law, and congratulations on putting a new law into effect in your community. That's how laws are passed. Question number two: eliminate the sale of high-capacity magazines, firearms, by limiting the magazine to 10 rounds. Yes, 28, no, 46. So you all are not going to limit the capacity of the magazine to 10 rounds. So if any of you are, I'd say, legislators from Colorado, the ones that did not pass the magazine, you'll probably stay in office. The ones that did pass the universal background checks, you might get kicked out of office. So let's have a nice hand for our people. And so at this point, we're adjourned. Please feel free to come up and chat with any of our panelists and Dean Wilcox.
But come to law school. Congratulations.